So welcome to you both. And my thanks to everybody who's bearing with us via these through these technology issues that we're having. Not quite sure which gremlins got into the system today, but we're just rolling with it. So thank you, Lauren, for your introduction. And in terms of just a few housekeeping issues, if you have any questions for any of the panelists, for Rachel or Michael, or even myself, could you please use the Q&A function? Chat function is basically for communicating with Courtney, who's sitting off to the side, just in case anything is not working. But in terms of any actual questions for the panel, can you please use the Q&A function, and I'll be keeping an eye on that. So without further ado, I'd just like to build on Lauren's introduction of Rachel. So Rachel is one of our 2 Ian Axford Fellows for 2024 in New Zealand. Rachel is Managing Director of the Liberty and National Security Program in Washington, DC at the Office of the Brennan Center for Justice. It's a non-partisan, non-profit legal policy centre and think tank based in Washington. Rachel's a lawyer by background. That's right. She works on issues related to national security, policing, and technology and civil liberties. It's just a delight to have you here today, Rachel. Without further ado, I just thought I'd actually, before we even get to how you got to the Brennan Centre and what you focused on there, I actually thought I'd go straight to, you could have chosen anywhere in the world. What made you interested in coming to New Zealand? Was it our Whittaker's chocolate?
Sure. Thank you. Well, and let me start just by saying kia ora koutou. Thank you really for everything. But to start, to both IPANS and the Office of the Privacy Commissioner for hosting this webinar, and of course to the Ian Axford Fellowship and to OPC for making this possible and for providing really such a warm and welcoming and vibrant community to come into and have this experience. So in terms of sort of what made me interested in coming to New Zealand and coming to do this fellowship, the Axford Fellowship is a really unique opportunity. If you're not an academic or maybe in business or in medicine, there aren't that many opportunities kind of mid-career to go experience something new, right? To expose yourself to a new environment, to different thinking on issues that you care about, that you've been working on, and to just have the experience of sort of thinking about issues in a new way and through a new lens. So the opportunity that the Axford Fellowship gives for as a kind of mid-career policy fellowship to do that, and of course it's specifically to New Zealand, really was quite unique. I had found out about the Axford Fellowship about 7 or 8 years ago through somebody who was in the United States on a Harkness Fellowship. And I'll give a quick pitch. The Harkness is sort of the reverse of the Axford, and I know that applications are open now for senior leaders in the New Zealand Public Service to come to the United States. But so I've become aware of this opportunity, and really it had been on my radar kind of since then. And then in terms of specifically, being in New Zealand, being with the Office of the Privacy Commissioner. So, my background, I know we'll be talking about this more, but the work that I do is really related to national security, policing, technology, and the impact on civil liberties and civil rights. And I was seeing that some of those same issues were playing out in New Zealand. So use of the same technologies, we're seeing use of license plate readers, of biometrics, of social media, and grappling with some of the same sort of consequences and just how the use of those technologies plays out for public safety, for national security purposes. At the same time, of course, New Zealand does have this centralized privacy office and function, and these powers that are very different from what we see in the United States, where it's much more kind of sectoral and siloed in terms of what those privacy protections look like. So I was really interested in learning about how that plays out kind of in and for New Zealand. And then, of course, in the United States, one of the things that we talk about in the context of law enforcement and national security use of technologies is impact on marginalized communities. So on communities of color, on immigrant communities, on LGBTQ communities, and seeing how those same issues were playing out in New Zealand, especially with respect to Maori communities, but also rainbow communities and others who are going to be impacted. And then just on a very personal level, so we're here with our family. So my husband and our children, my daughter Sarah, who's 12, and my son Eli, who's 9, almost 10. And I really wanted to give them the opportunity to experience life in another country. And that has been just enormously wonderful and enriching for all of us.
Fantastic. And I remember, I'm really pleased you mentioned the Harkness, because I know that Ian Axford is about that exchange of ideas, and IPANS is also about connecting people and ideas. And the person who you met through the Harkness was the person who reached out to me and said, "Hey, there's this wonderful person who could come your way."
I'm very grateful to her.
So I really do think that things like the Axford Fellowship really are useful in that respect. And Michael, I wonder if you might reflect on that.
From my perspective, I talk to a lot of privacy professionals, regulators in other countries. I get out of Wellington and I speak to people from the business community, in particular in Auckland. I speak to those who are working within government agencies here in Wellington, and there's an increasing focus on how to be more efficient and effective in delivering government services and delivering businesses services to customers. At the same time, there's the advent of new and better technologies and digital tools, which create, from one perspective, new opportunities, from another perspective, new risks that need to be managed. And underpinning all that, I think we can see around the world, a world that is at times increasingly fractured, a increasing discourse around what are the fundamental rights that we hold dear, the things that we believe should underpin a free democratic society. Of course, obviously the right to privacy is one of those. And so when the opportunity arose to have someone who is an acknowledged expert in an area of public policy come to New Zealand to do a deep dive into such a topical area of public policy, Liz, I thought this is an opportunity we should grab with both hands.
Absolutely, I endorse that entirely. So let's take a step back. And you are the managing director of the Brennan Centre. You've got this whole area of focus. How did you get there?
Sure. So as you said, I'm a lawyer by background, by training, but I took, in some ways, a little bit of a circuitous path to get to the Brennan Centre. So I've been at the Brennan Centre for about a dozen years now.
Oh, and by the way, we don't have institutes like the Brennan Centre in New Zealand, and we are jealous of them. But tell us a little bit about the institute, just a wee bit.
Sure. Yeah, no, it's a great question. So as you said, the Brennan Centre is a nonpartisan, nonprofit organization. And there is a big nonprofit sector in the United States. So I think of the Brennan Centre as being situated within civil society, right? So organizations that are trying to, make an impact on policy, on kind of public opinion in the United States. The Brennan Center was founded in 1995, so about 30 years ago. And it was founded as Justice Brennan, who is a justice on the U.S. Supreme Court, was stepping down from the court. And the idea was to start up a center that was dedicated to his progressive vision of the Constitution. And I always describe it as sort of being dedicated to shoring up the systems of democracy. And that takes place through really a variety of work. We do a lot of research and writing. We advocate to policymakers. We advocate in the courts. We do quite a bit of public education. So there are kind of these different tools that we have to try to shift policymakers and the public and the judiciary on some of the issues that we see as really core to how our democracy is.
And your root there?
Yes, so my root there. So I didn't actually start out in the nonprofit sector, although I got there fairly quickly. So right after graduating from law school, I spent a year as a clerk, although I understand that here it's pronounced clerk, following the British model. But I spent a year basically working for a judge in the United States. So a judge on the Ninth Circuit Court of Appeals, a federal appeals court in California. And from there, I had sort of decided that I thought I wanted to do something policy related and that I really wanted to be in DC, where I had never lived before. I'd spent probably a week before in DC, but it had seemed like a place where people were doing work that they were really passionate about and doing really interesting work. And it sort of happened that the way that I found to come to DC was actually at the outset to work for the US Department of Justice. And so I came to the Department of Justice through a program called the Honors Program that put me in the Civil Rights Division of the Department of Justice. So I was working in a section where we were litigating Fair Housing Act cases. So the Fair Housing Act is one of the civil rights laws in the US, prevents discrimination in housing on a variety of factors. So I spent several years at DOJ litigating those cases. Decided, as I had been pretty sure was the case, that I didn't actually want to litigate full time. And I was sort of looking for something that would use my legal training, but not in the courts. And so from there, I went to a nonprofit organization called the American Association of University Professors, which is about 100 years old and is dedicated to the kind of preservation and protection of academic freedom and tenure. Again, in some ways, as kind of pillars of a democratic society, ensuring that there is freedom in higher education to pursue and research and speak about issues. And I was in-house counsel at AAUP for about 5 years. So doing a range of work representing the organization on kind of just a whole bunch of different legal issues that would come up. And also spending a lot of time researching and writing on and speaking on especially the intersection of academic freedom and First Amendment rights. And so those are rights protected by the First Amendment to the US Constitution, things like the right to free expression, free association, freedom of the press, things like that. So sort of thinking through those. So when I first started thinking about leaving AAUP and was thinking about these sort of two different paths, whether I was going to stay on that in-house counsel path and maybe in higher education, which is a really wonderful community, or pursue those First Amendment civil liberties issues. Those were really what I felt most passionately about and was just incredibly fortunate to land in this position at the Brennan Center. As you said, so the Brennan Center is divided up into several different programs. The program that I'm in at the Brennan Center, and for which I'm now managing director, is called the Liberty and National Security Program. And just sort of briefly writ large, it focuses on issues at the intersection of civil liberties and national security, and kind of more broadly policing and technology. But so that was kind of my in. I did not have a particularly strong background in national security. And so that was actually a fairly big learning curve at the beginning. But getting to work since then for the last dozen years on issues of civil liberties and civil rights has been just incredibly rewarding.
And so I'm thinking about the intersection between that and what you're going to be doing here. You've had a real interest in the use of social media monitoring, including things like license plates and other things, from a law enforcement and surveillance perspective. Can you sort of move from that into the project you're going to be focusing on? And just by the way, somebody's told me there's a lot of light coming in behind you.
Okay.
So while you're talking, I'm going to do some adjusting.
No problem. Yes, so I can, if it's helpful, sort of lay a little bit of the landscape in terms of talking a bit more about the work that I've done at the Brennan Center, and then how that does, as you say, sort of tie into the project that I'll be working on here, and that I started working on at the Office of the Privacy Commissioner. So at the Brennan Center, right, I was mentioning sort of this, broad scope of work that has taken me through several different projects and areas. And I'm, happy to get into that more at some point if that's of interest, but kind of focusing on the project here. So for the last probably 5 or 6 years, at the Brennan Center, one aspect of my work has been looking at the use of social media by law enforcement and security agencies for information collection, right? So it could be for intelligence purposes, for sort of situational awareness, for investigations, things like that. And that has taken a variety of different forms. So we've done public records requests to local law enforcement, to local police departments around the country, which has ended up yielding a lot of information about how especially some of the departments have done their social media work, and how some private entities, sort of these private, like third-party social media monitoring companies, have marketed their services to police departments. So for instance, we found out a lot about how the Los Angeles Police Department was doing social media monitoring. We ended up turning up information actually that Meta, of course, owns Facebook and Instagram, was then able to act upon, including filing a lawsuit against one of these companies. We did a report about how the Department of Homeland Security uses social media, did public records requests to DHS and others. And so that was really sort of the hook for what I was interested in researching and writing on as an Axford Fellow, in part because there had been reporting about use of some social media monitoring tools by agencies here, by sort of law enforcement or law enforcement adjacent agencies. And so it seemed like it could be a really interesting landscape to learn more about and to kind of bring the benefit of the work that I had already done. So the research that I'm doing here and the report that I'm envisioning writing I expect will take sort of several parts. So the first piece is kind of a landscape of the use of social media by either law enforcement agencies or agencies with an enforcement or investigative or fraud detection function in New Zealand. And this is drawing, at this point from, largely kind of what's publicly available, but kind of building up the understanding of how social media can and is being used as a tool. And obviously this is very much in the post-Christchurch landscape, right? And we know that there's a lot of concern about the spread of extremism online, about online radicalization, about the spread of misinformation and disinformation online, and just simply the myriad ways that social media is used for communication and, it can include, evidence of criminal activity, all those sorts of things. So trying to set out an understanding of what these different uses look like and what are some of the important ways, right, in which accessing social media could contribute to public safety, to kind of the national security. The second piece is doing, something of an overview or taxonomy of what are, given all of that, what are some of the potential harms or concerns coming out of use of social media for these purposes. So just by way of example, and some of this I had alluded to earlier, right? There could be a disproportionate impact on certain communities, right? On Maori communities, on rainbow communities, on others, on activists, depending on how they're using social media, depending on how those are being used by agencies. There are concerns around and just questions around sort of how sort of interpretable, how contextual and open to interpretation social media is. So if somebody's using social media in one way and they're part of an in-group or trading jokes or trading kind of cultural references, what are the pitfalls with someone else looking at that and kind of trying to interpret it? And so there are all these ways that we see social media not necessarily, it can be of value, but can also have these pitfalls and weaknesses. And then the third is considerations for agencies to keep in mind, right? As they're thinking about using social media in these ways, or maybe they've undertaken it, really just what are questions to ask? What are things to be aware of? And so that's sort of the overall framing of the project.
Really critical questions that are being asked a lot. We as you know, Michael, one of the questions that you were going to talk to last year and also this year is, what exactly is publicly available information when you're thinking about social media monitoring? That is a question that's come up for us.
Yeah, absolutely. And to pick up the point that you're making, Rachel, we are potentially also seeing an increase, not just here but around the world, of government agencies potentially feeling limited either by law or by public opinion from engaging in the sort of social media mining, but feeling that they have therefore the freedom to contract out that service to a third-party provider, and in the sense that that's in some way okay. But our focus here very much in the office, as you know, is actually what is the principal and that principal agency relationship responsible.
And so it's one of the things about new technology is that it provides new and different sources of information that in the past would quite definitely have been seen as being private, and now, because it's available through a particular type of technology, is potentially seen as being available for use. You've seen that in the States?
Yes, absolutely. And I think very much to your point, right? We do see that playing out over different types of technology, right? So I think social media, I was going to say it's the most recent one. I'm not sure that's quite true, but certainly that's where there's certainly a lot of kind of debate swirling around social media, and there's just so much information available. And often it is, in fact, whether it, there's sort of a question about, right, what the principles are and what the practices are or policies that should drive access to it. It is often quite freely available, right? So there's an enormous amount, I think, of social media sort of mining that's happening. But we see it with other technologies too. So certainly in the United States, I know that some of these have come up in New Zealand as well, looking at license plate information. And then often there are questions about, like, well, for what purposes? How long is that data being retained? Cell phone tracking, and that's an area where the U.S. Supreme Court has weighed in on aspects of that, right? So there are technologies that could be used to determine, where a phone is or who a phone belongs to. But the court did weigh in several years ago to say, well, when the government or when a law enforcement agency goes to a cell phone provider to say, we want, X amount, especially if it's, many days or many weeks of somebody's historical cell phone information that shows all those pings, that shows where they're going all the time. Actually, we think that, right, for us, we see it through the lens of the Constitution. So the Fourth Amendment protects against unreasonable search and seizure. So the court said there, as they are increasingly starting to see in the technological context, that the window that data gives into somebody's whereabouts, which is really a window into their life and into often a lot of really sensitive and intimate aspects of their life, where they're spending the night, what their daily routine is, where they're going to meetings, that is so sensitive, and that this data makes it so easy and so cheap to learn that information and to sort of deduce those kinds of determinations about people, that actually rises to the level of something that is constitutionally significant, because it's so far beyond what police or what the government would have been able to do kind of at the founding of the country, right? So we see that with some cell phone data, with things like GPS tracking. But I think at the same time, we're still very much like working our way through how that plays out for different technologies. And I think social media does raise additional questions that we grapple with, because at least some of it is voluntary. People are putting some of it out there in the world. Not always, but so then that raises, I think, additional questions.
And just on that subject, it's also, I guess, the technology available to aggregate the social media data.
Absolutely.
The increasing use of AI and other powerful tools that once upon a time, you can think about your data scattered all over the internet, all over social media. Some of it you made publicly available, some of it you never thought would be, but now tools can bring all that together.
I think it's a really critical point. Yeah.
I agree. And I think just before I go to some of the questions that are coming in here, I know that something that would be put to both of you, certainly put to the Office of the Privacy Commissioner quite often, is so, you know, if you're thinking about, is there a balance to be struck between privacy and the safety of the community? And how do you find your way through this? And if you can use this information to find people who could do others harm, shouldn't you?
I'm happy to take a first stab at that, but I'm hoping that that Michael will add on as well. I mean, I do think there's a balance, and I think that, you know, one of the things we often talk about in the context of social media, and in some ways, unlike some other surveillance technologies that I think sort of lend themselves sometimes to more of a bright line, you know, this technology shouldn't be used because it is so susceptible to misuse, or it should only be used with a warrant, that the different kinds of use of social media, you know, there are kind of different ways it can be used that raise different benefits and harms. From my perspective, really, the key is building in guardrails, having transparency around what the policies are, ensuring that there is accountability so that when agencies are using social media in some way, that it is clear and kind of within articulated, you know, policy guidelines that do, you know, both enable those kind of reasonable law enforcement or security functions, and at the same time build in protections, you know, both because, you know, we know about the potential harms that can arise. You know, we know about the possibility of, you know, what we often refer to kind of as surveillance creep. You know, so if a technology or capability is sort of approved or in use for one purpose, then there's sort of the concern that, like, well, we use it for this, maybe we could use it for this, or we have this data for this one purpose. Now, you know, it's in place, we can use it for this other purpose. Obviously, that's something that the Privacy Act very much speaks to. And also, to Michael's point, I think being really attentive to the ways that new technologies layered on social media and thinking more broadly about the social media ecosystem play into this, right? So I could even not use social media at all, and there would still be information available about me by virtue of what other people are posting. And all of those things that I think sort of complicate the analysis as well. But absolutely, I think a lot of it is about striking balance.
Absolutely. I mean, we never say the right to privacy is absolute. There are carve-outs in our legislation here, Rachel, as you're aware, for public interest reasons of law enforcement, public health, those sorts of things. One of the phrases that I don't like to hear is people saying, if you've got nothing to hide, you've got nothing to fear. And actually, my retort to that is a number of things, one of which is we have a right to be let alone. We have a right to privacy. We have these important fundamental rights. We should always remind ourselves about the importance of those, because it relates to essentially what sort of society we want to be. There are societies around the world which have different attitudes towards privacy, towards surveillance by the state or other agencies. And we regard ourselves here in New Zealand, I'm sure in the States as well, that we are not like that for good reason, historical reason, but also because of the values we hold dear. We have a different view. I guess another angle on all that is the potential with the increasing, I guess, capturing of data and use of that data is the increasing potential for mistakes. Mistakes are always made. We acknowledge that in all areas of public policy that we do. Increasingly, though, those mistakes could see people facing significant, I guess, negative consequences for themselves, how they live their lives. They may not even know that negative decisions have been made about them simply because of the way the data has been captured and used about them. And so those privacy principles of transparency, openness, and knowing who's capturing information and what it's for, I think become increasingly important in the face of the use of this technology.
Which leads on to a question that I've got here, which is if government agencies, it goes to access to information. If government agencies are collecting data on identifiable individuals, what what powers do individuals have to access what's held on them by other agencies?
Right. Well, under the information privacy principles, there is the principle of access, and you have the right, with a few exceptions, acknowledge that, to request information that is held about you by government agencies. That is one of the strong, in fact, there's often used ones in privacy legislation here in New Zealand.
We've just followed up on that one. And then we've got another question here, which I think both of you could reflect on, which goes to whether you think that specific legislation is actually needed to deal with the new aspects of social media, or can we actually rely on our existing frameworks, and particularly in New Zealand, I guess, the principle-based nature of them?
I will not purport, I think, to opine on whether there needs to be new legislation in New Zealand.
But thinking about the state.
But certainly, I mean, one of the things that we've really pressed for in the States is both having legislation and having much more stringent policies in place. So one of the things that we've seen from our research, we did kind of a survey of ultimately about 160 police departments across the country. So we looked at about the 330 jurisdictions that had more than 100,000 people, and of those which had law enforcement agencies that had publicly available policies on use of social media. There's about 160 of them. And most of those weren't, I think it's an understatement to say they weren't nearly as robust as we would have liked to see, right? So I think there's a lot of room for much more stringent policies, and then very much for legislation. I think probably realistically in the US, to the extent that's going to get traction, I think right now it's most likely to be at the local level, right? Maybe at the state level. I think it's fairly unlikely at the federal level. But given how, especially because we don't have something akin to the Privacy Act, it is essentially kind of a Wild West right now in terms of how law enforcement agencies can use social media. And so I think both of those pieces, better policy and bills in place, I think would be enormously important.
I guess from my perspective, Liz, I think with the increasing use of social media, including by young people, something like a legislative right to erasure would be useful. There are many people out there, increasingly, I think, who regret something that they've posted or something they've said, a photo, perhaps that sort of thing online, and they don't want that to be part of something that's captured by a data aggregation surveillance tool going forward, and they should get that right. I think there also is increasingly a need for some sort of accountability loop where agencies have to actually be quite specific about why they're seeking the information that they are seeking and the reasons for which it will be put to. So there's greater transparency and a sense of accountability.
I've got one question, which is the writer apologises for being possibly a bit off topic. But they've said that the US is generally sort of seen as being a bit more litigious than New Zealand.
That may be fair.
And that you mentioned that the Brennan Centre tries to influence the courts through expert advice. Essentially, the person was asking whether there are tools that we could use in New Zealand to try and influence in the same way, or are we likely to have to continue to rely on court precedent and that sort of thing?
Such a good question. I think in some ways I am still in the process of learning more about how the judiciary operates in New Zealand, and I've had the opportunity to, for instance, see the OPC's involvement in the Tamafuna case, to read opinions coming out of the New Zealand courts. I think there may be some different tools in different ways, but I can speak a little bit to how we have used or tried to influence courts to the extent that kind of suggests potential avenues. So one is we and another number of other civil society organizations are quite active in an amicus capacity. And I'm not sure if that's a model that quite exist here. But the idea behind being an amicus or submitting an amicus brief is that you're sort of, quote unquote, a friend of the court, right? So the idea is that you're not one of the parties to a case, but you have particular sort of expert input, or you represent people that have expert input or an important perspective on how the court should be thinking about the issue. So not in terms of the facts, but in terms of the governing law, in terms of social or historical context, something where you could say to the court, here's something that you need to think about in terms of making your decision. So in the context of cases related to surveillance and technology, there are cases in which we have participated as an amicus where a court is making a decision about, right, it comes up in the context of an individual defendant and the use of a technology in their individual case. And often amicus briefs or amici can play the role of saying, you need to kind of zoom out and take a wider perspective on this, because if this particular kind of law enforcement power is permitted, or if this particular kind of technology can be used without really strict controls, this is what it would look like, or these are the kinds of abuses that it would empower, what the impact could be, right? So that's one way that we, ultimately try to influence, kind of educate the courts and influence the outcome of cases. Another is, I mentioned that we do quite a bit actually of public records work. And so those are requests to local law enforcement agencies and a lot at the federal level. So especially just given our work to the Department of Homeland Security. We most often find that we need to file suit in order to actually get the documents that we're driving at. So that's a fairly sort of straightforward way of using the courts, but in bringing in kind of that power to ensure that the openness and that sort of the promises of the Public Records Acts are vindicated. And then the third is, in fact, filing suit on behalf of people. So my program has been somewhat less active in that kind of litigation. But for instance, we worked together with some other civil society organizations and a law firm in representing a group of plaintiffs that were challenging the Muslim ban when President Trump was in office. We've worked on other cases. My colleagues and other programs at the Brennan Center have been very active, for instance, in litigation related to access to the ballot and kind of free and fair elections. So I'd say those are the ways that I see sort of those techniques and that avenue being of use in the overall work that we're doing.
And I think the amicus sounds, well, most similar to our ability to intervene.
Yeah,
we did the other day with the Supreme Court. This is going to be 2 more questions now, and we're starting to run out of time. So I will make a promise to people that if you put a question down here, we will seek to find a way to answer it, and maybe online. And Rachel is also contactable here via our inquiries line. If you just email that. So we've got 2 last questions. We'll see if we can get through both of them before we need to close up in about 5 or so minutes time. So the first one was actually, do you have a view on monitoring versus investigation, how they fit together, i.e. using keywords to pick up issues where there was no suspicion versus using targeted searches on already suspicious activity to get more information for a criminal investigation or terrorist activity?
So I will say, I feel like this questioner was like reading my mind and throwing me a lifeline, because actually one of the things on my mind as we were talking was thinking, I'm not sure that I, completely articulated sort of the distinction between those two, which I think is actually a really, really important one, and something that Michael had said had also, I think, picked up on that. So I do think there's actually a very important difference. So those kinds of targeted searches that could be done for an investigation, I think those are, they can absolutely, they could be, misused. They could be used for pretextual investigations. They could collect too much information. It could be, kept for too long. But those are the kinds of uses around which you can see if there is, good policy in place, if there are good guardrails in place, if there's language around, what information is collected, how it's used, how long it's kept. I think you can see those as legitimate uses for the information that is out there on social media. That kind of broad scale, where what you're doing is, using a keyword and sort of throwing it out into the sea of social media, especially is one of those places where I think we have really significant concerns, both because it is so sweeping. There is so much information that you can pull in. I think it is so susceptible to misuse, including in intentional ways. I mean, one of the things that we have seen with agencies and police departments in the US is, using things like hashtag Black Lives Matter, hashtag hands up, don't shoot as a keyword that's being searched on. But then I think the other piece, honestly, is efficacy of that kind of tactic, that if you're looking for a threat, that they're kind of in the enormous sea of social media, there is so little chance that it's actually going to turn up something useful, whether you're in the public safety context or even the counterterrorism context. There have been a lot of really important, really credible research and writing about how ineffective that kind of monitoring is for those purposes.
That's really useful. I'm going to keep going because the questions are starting to flood in thick and fast now, just as we're getting towards the end of our session. So, how has the user consent approach impacted the development of information gathering tools and civil rights protections? Do you think there might be a feasible alternative?
It's a great question. I don't know if I can speak to that as much. I mean, I think my only sort of, initial reflection is, and I do think we're starting to see the ways in which user consent is a somewhat weak tool for protections, because what does it mean to consent to the kinds of information collection that happen? If you're consenting to use some kind of technology or some kind of tool, you really know what you're consenting to? Do you have a choice in that consent? So I think that's what I would look to. But
that you're touching on an accountability approach, which might take there.
I mean, I think there is choice. There is no consent. If there is a fundamental service that you need, and to get it, you have to consent basically to opening up your entire digital life to the agency concerned. Now that raises really interesting questions. I think, and there's an interesting hierarchy of agencies, particularly in your study, Rachel. There are, of course, we know everywhere in the world there are intelligence and security agencies that have particular statutory powers in relation to privacy, and that's well understood. But it's the increasing, I guess, below that tier, there are law enforcement agencies, and then there are other agencies. It's the nature to which those agencies are increasingly perhaps moving into the space of having similar powers, or being able to transactionally purchase similar powers to what intelligence and security agencies have. And now I think that's actually a really interesting public policy discussion of debate.
We've got a question here about data minimization, and whether data minimization is a type of defense strategy for potential AI risks associated with social media companies. In terms of essentially, I guess they're getting at the unknowns about what the data might be used for in terms of identifying individuals in the future. And data minimization is an interesting principle when you start considering the scope of information that can be collected by AI. And in fact, you could argue that AI is about data maximization, not data minimization. But reflections on that principle. I mean, it's been an underlying principle for us.
I guess that's where our thoughts around the right to erasure come to play as well. Was actually what is, and there are already existing kind of, I guess, data to be mined for individuals out there. And it's a question of how can you minimize that now in the face of new technology? Are there the freedoms for people to do that? There are in some countries. So there's going forward from this point in terms of a stronger focus on data minimization across the use of those tools by agencies. There's also historically looking back, what can you do about what exists already?
Yeah, well, unfortunately, I think we've come to the end of our time. As I told you, it's going to race very quickly, even without our technology problems at the beginning. So I'm going to flip back to Lauren shortly, but just to say thank you so much, Rachel and Michael. The whole point of the Axford Scholarship is to allow for this rich exchange of ideas and for us actually to end up learning and being, both of our approaches being more robust as a result of that. And I'm sure that's going to happen, as well as having a lot of fun in the meantime. So Lauren, just flicking back to you.
Brilliant. Thank you, Liz. Apologies, my camera doesn't seem to be working on the call today, but I am here. So thank you, Liz. Rachel. Can you hear me? Can everybody hear me? Okay, I think people can hear me. Thank you, Rachel, Liz, and Michael. That was a really insightful discussion, and thank you for the audience for those brilliant considered questions. As mentioned before, if you do want to get in touch directly with Rachel, please do so. I'm sure that she'd be more than happy to carry on that conversation. Please do also check out the Axford Fellowship website for further information generally on the fellowship. And if you'd like to reach me, you can do so on fellowships@fulbright.org.